we continue Chapter 4, Privacy. This is Part 5 of 7, Monitoring and Data Analysis. The learning outcomes include: explain the basis for protecting personal privacy under the law, and demonstrate how employers are increasingly using workplace monitoring. Let's look at consumer profiling. That never happens, right? When we talk about profiling in the context of the internet, we mean information that is obtained about you simply because you are online surfing the web. If you've ever tried to search without you using cookies, you know it's next to impossible. Cookies are very small files that are stored on your computer. They remember your login information for different websites and collect substantial information about you when data is put together. Tracking software and apps also learn about you, surreptitiously watching you online. Is it legal? Pretty much, unless it violates laws like HIPAA. The obvious criticism of consumer tracking is that personal data may be, or is, gathered about you and then sold to other companies without your explicit permission. They don't need it. You give them permission to collect your data when you voluntarily visit their website. You probably click on I agree for terms of agreements and don't read, like all of us. Simply assume that everything you do online is monitored and recorded. You may take protections to anonymize your surfing experience, but be careful. Some apps and software that appear to be intended to help you avoid consumer profiling may actually contain malware or other files that collect your data. So you're damned if you do and damned if you don't. There must be limitations on workplace monitoring, right? Not much. The best thing a company can and should do is to provide an IT usage policy, which establishes what you are and are not allowed to do on your work technology. With a policy in place, management can and should enforce it equitably to all levels of employees. If an organization monitors, they should tell employees that they are doing it. There are many valid reasons to monitor employees: to protect against espionage, harassment, installation of unapproved software, use of company equipment without approval, technology, desk, phone, Wi-Fi, etc., to complete personal rather than professional tasks, and so forth. Can't use Facebook at work? Well, tell them. Tell the employees. No use of network connections for non-work activities? Tell the employees. You plan to videotape their activities? Tell them. It's better to prevent than to try to catch employees doing something wrong. U.S. citizens argue that the Fourth Amendment protects from unreasonable searches and seizures, and they should have privacy at work. While that argument does apply in a limited sense to government employees, it does not necessarily protect your non-governmental company from doing what it wants to do. As you can see, U.S. federal and state government employees actually do have some privacy rights as given in the Constitution. Some state laws provide additional protections for employees. In general, however, state privacy laws favor employers over employees. You're using their technology or their electricity or whatever it is, and they have a right to see what you're doing and protect the organization from activities that they declare off limits. In general, public sector employees have far greater privacy rights than those in private industry. And as mentioned, the state privacy statutes tend to favor employers over employees, just like the federal statutes. Let's take a look at one of the precedent-setting cases involving workplace monitoring. Pillsbury told its employees over and over again that all email messages would be confidential and that the company would not intercept or read email. Even if they did, they promised that they would never use email messages as grounds for termination. You know what's going to happen now, don't you? Of course, Smith sent an email to his supervisor that threatened some of the sales staff. The supervisor reported him and Pillsbury fired him. Smith sued, saying that Pillsbury had violated his privacy right. Pillsbury asked for the case to be dismissed and decided in their favor. When making the decision, the trial court looked at the facts. First, Pennsylvania is an at-will jurisdiction, just like Georgia. At-will means that you can be fired at any time for good, bad, or no reason, as long as you aren't if it's not because you're a protected class in the U.S. Constitution. You can even be fired for not following an illegal command. If that happens, then report it to the authorities and get your revenge that way. You can be fired for wearing an ugly shirt or simply looking at your boss and irritating him or her. Similarly, you can quit at any time as long as you're not under contract. You can quit for any reason, good or bad. You may not like the shirt your boss wore that day, so you quit. Or he or she irritated you by asking how you were doing. At will gives rights to employees and employers. Contract law, and sometimes union law, supersedes these rights and requires you to follow the rules you agreed to in the contract you signed. The court decided that Smith gave no valid legal rule upon which the court could evaluate his dismissal. He should not have expected privacy in email messages, particularly after sharing with another person. Smith voluntarily gave his opinion and was not forced to do so by the company or his supervisor. According to the reasonable person standard, the court determined that reading email messages was not a highly offensive invasion of privacy. In fact, a company is obligated to know what its employees are doing, since in most cases the company is legally liable for employee activities. Further, the company had a legitimate business interest to protect against illegal or unprofessional comments, and those interests outweigh Smith's right to privacy. Thus, the case was decided in Pillsbury's favor and was dismissed. Private and other non-governmental agencies watched the Pillsbury case with interest and learned from it. If the organization plans to monitor its employees in any way, tell the employee so that you reduce expectations of privacy. If email is to be used for business purposes only, tell the employee. If you may monitor any email messages, whether work-related or not, tell the employee. There's a pattern here. Policies that clearly outline employee behavior should set employee and employer expectations accordingly. In almost all cases, the right of the employer to control and access all data completed using any work facilities and or technology is considered almost absolute. The lack of right to privacy is almost absolute. So let's look at an example that clarifies some of the information security policies and provides guidance on appropriate wording. Marina Stengart worked at Loving Care Agency, which provided care services for children and adults. In December 2007, Stengart wrote several emails to her lawyer from her personal password-protected email account using a company-owned laptop. After Stengart resigned, Loving Care hired a computer forensics expert and obtained the hard drive of the computer used by Stengart and all of the email messages. Stengart's attorney, Donald Jacobs, asked for all emails to be returned and copies destroyed. He argued that there is a reasonable expectation of privacy in personal emails on company computers and that attorney-client communications protection should not be violated. The court, however, decided that the emails were not protected by client-attorney privilege because the company's policy indicated that the emails were a part of the company's property. The appellate court, however, reversed the trial court decision and said there was improper respect for attorney-client privilege. Loving Care appealed the decision to the New Jersey Supreme Court for the final ruling. The New Jersey Supreme Court evaluated all the evidence and decided that the attorney-client emails were privileged. There were several reasons why this case was decided in favor of the plaintiff. This is not a typical case. Most cases decide in the favor of the employer. Decisions in different states might be different. In this case, the employee privacy expectations were higher for a couple of reasons. Attorney-client privilege is a separate and distinct right from personal privacy. It carries more weight than employee or employer privacy. The policy at Loving Care did not specifically say that email checked using company technology had no expectations of privacy. They didn't say whether it did or did not have expectations of privacy. The password for the personal email was not stored on the company server, so Stengart had taken some extra efforts to protect the email messages. There was a legend on the email messages stating that the messages were privileged and subject to attorney-client privilege. Again, this case is not typical. Most cases are decided in the employer's favor, and employees should expect no privacy rights at work. However, as IS professionals, you can help your end users understand the clearly written policies so that there are few or no misunderstandings. I've included some of the references I used for this case, and feel free to check out a couple of them to read more about the case and the decision. There are several points that are important to note. First, in this case, the court determined that Stengart had an expectation of privacy in emails with her lawyer. Thus, as IS professionals, we must seek to understand the legality of accessing and reading employee emails and understand that there are limitations to our rights to access. However, the court specifically stated that the decision does not mean that employers cannot monitor or regulate the use of workplace computers. Companies can adopt lawful policies relating to computer use to protect the assets, reputation, and productivity of a business and to ensure compliance with legitimate corporate policies. And employers can enforce such policies. They may discipline employees and, when appropriate, terminate them for violating proper workplace rules that are not inconsistent with a clear mandate of public policy. The decision reinforces how important it is for us to design acceptable use policies that are clear, understandable, consistently enforced, and not in violation of public policy, in this case, attorney-client privilege. Next, the court said, because of the important public policy concerns underlying the attorney-client privilege, even a more clearly written company manual, that is a policy that banned all personal computer use and provided unambiguous notice that an employer could retrieve and read an employee's attorney-client communications if accessed on a personal password-protected email account using the company's computer system would not be enforceable. In other words, there isn't a policy that can supersede attorney-client privilege, at least not one that the courts mentioned. Write good policy, but remember that common sense and public policy will sometimes override even the best written policies. And you can't think of everything. That's why the acceptable use policies are rewritten and updated often. Finally, the court said that defense counsel erred in deciding not to set aside the emails upon determination of their potential privilege and notified plaintiff's counsel of their possession of the emails before proceeding. Thus, there were several errors made by trial courts, as noted by the New Jersey Supreme Court. In summary, organizations collect substantial information on consumers and are obligated to protect the information collected. Companies should develop IT usage policies and ensure that employees give affirmative assent to abide by the policies. Employees should assume they have absolutely, positively no privacy at work. While Stengart versus Love and Care did find in favor of the employee regarding attorney-client privilege, that was a very narrow interpretation, and far more courts find in favor of the employer over the employee.